We start with our legal analyst, Michael Coyne. And Michael, what does today's filing actually mean for Tom Brady and his legal team?
Well, it's the last stage of what will happen at the Second Circuit Court of Appeals. He is now asking either that there be a rehearing before the same three judges, or more importantly, as he would see it, a hearing en banc before the entire panel. It's a really long shot that they're likely to undertake any further review of this in the Court of Appeals.
All right, so if it's a long shot to make it through the Court of Appeals, Michael, what about the chances of it going to the Supreme Court?
I think it's just as long, but statistics you have to almost throw out the window in a case like this, because there really was statistically unlikely that Berman would have reversed the arbitrator's finding, and statistically it was unlikely that the Second Circuit Court of Appeals would reverse it. So statistics are meaningless, but the problem is that the law is heavily against Brady as well.
Are we, though, seeing a change in strategy by the Brady camp? And if yes, how and why?
A little bit, because now Brady has to represent every man. It can't be about the NFL. It can't be about a star quarterback. What it has to be about is all of the folks out there that have union agreements, that have collective bargaining agreements and arbitration provisions. And they're very common in both public and private employers. And what he has to say is, now, if you let this happen to Tom Brady, you're allowing every working person throughout the United States their rights to be trampled on, and that's what he has to really convince the court, is that there's a much bigger picture at work here, and the harm under the law is severe.